exclusivity, which to me is a bad word because it means that I can't pursue the case for tort. And usually if someone wants to say they've got intentional infliction of emotional distress claim or a reckless infliction of emotional distress claim, you get these arguments it's preempted by workers' comp. Sometimes you get that on assault and battery. And it's not. There's case law saying it isn't, but that's been the fight for me. We also are talking about medical treatment and workers' comp, which is a really big issue. You don't want to be stuck with the company clinic. Seth, you told us about something called an admitted injury case. Maybe you should explain what admitted and non-admitted means to the listeners in workers' comp.
Okay, so to begin with, if you're on the admitted injury track, that means that, you fell off a ladder, you broke your arm, it was observed by witnesses, and generally in that instance, the employer, assuming that they have workers' comp insurance, they're going to provide you with a claim form and send you to the appropriate type of medical specialist within a reasonable period of time, sometimes as little as 24 or 48 hours, 72 hours, depends on the nature of the injury. If the employer tells that injured worker in an admitted case that we are going to provide care, and here's a list of the group of doctors, then an injured worker who's on his own, not represented, sort of, for lack of a better term, at the mercy of an insurance company, doesn't know who the doctors on the list are, doesn't know if those doctors are going to be sympathetic to them, or it could be just Kaiser. And, in a situation like that, the injured worker is not likely to be able to get the medical evidence that they need to later prove their case.
Is there a way that you can go to your own doctor if you have a work injury?
There is. It's rare. Injured workers would have to pre-designate at the time of hire or at the time that they're notified of their medical provider rights. That would be one instance. The other instance is in a denied claim. Denied claims are just what they sound like. Employer doesn't witness the injury. Employer doesn't believe the injury. Employer wants more medical evidence before they'll admit the claim. And in that instance, within the delay period, the employer is supposed to pay for up to the first $10,000 of medical treatment, which should be an incentive to doctors to want to take on those cases, because that first $10,000 is out there to be paid by the insurance. But the way that insurance companies have cracked down on doctors collecting their money has really limited the number of doctors who injured workers can be sent to outside of a medical provider network, unless your attorney is familiar with the area where you live, the providers that are either on the medical network if you have to use them, or there'll be doctors who will see those injured workers on a lien, and then those doctors expect to be paid by the insurance carrier later because the injured worker only receives. That's a critical component.